Thank you, Jimmy. Sometimes I think instead of keeping that document as an evergreen, I'm chopping at the bottom of it, trying to change its color. But we've been working real hard the last year on the UAA and two what seemed to be cantankerous issues as we work through them. But thanks to the hard work of the committee, and I think the committee from the NASBA side is listed in your materials. And let's see, I got this thing. I'm supposed to do this myself. You think I can do it? No, I went the wrong way. There you go. So that's the people that are on the NASBA committee, and they worked very diligently and very hard this past year as we worked through two major changes to the UAA, and that being a test and mobility. So we'll talk a little more about that as we go through this. Remember that the UAA committee is a joint committee. We have 12 members on that committee from the NASBA, and then the AICPA also has 12 members on that committee. So when you stop and think about that, we've got 24 people that we have to get to agree on changes to the UAA document. And people, that's a task in and of itself. So we worked through it. I'm here to report that we were successful in our efforts, and that we had two major changes to the document this past year. First of which was to change the definition of a test. Now, the reason for the licensure at all is so that we can maintain the test function as is defined in our UAA to only CPAs. And as we began to look at the history of the UAA in and of itself, that's the reason that we have started, and that's the reason we maintain it, and that's the backbone of the UAA document. A test replaced the old word that we used of practice, and that was a needed change because some of the things that we do, other people were doing, so we didn't want to infringe on what other professions might be able to do, but we did want to restrict the test function to CPAs. Test is used 21 times within the UAA itself and 23 times within model rules. Now, this particular change really started coming about back when the ASB, we can point our finger at them, can't we? Because they moved the SAS 70 engagement from being under the Statement on Auditing Standards to the SSAEs. Now, when they did that, without realizing it, we moved and a test engagement from the SSAEs, from the SASs to the SSAEs, which opened the door for anyone to perform that function under the old wording of a test. So we put some Band-Aids on it and tried to define a test as it was stated in the SASs as of a particular date until we had time to work through the UAA and come up with a new definition. Now, I made a little fun at the ASB, but I have to tell you, I was serving on the ASB at the time we moved SAS 70 from the SASs to the SSAEs. So I have to take some responsibility for that as well. But having said that, once we did that, then we began to look at it from the definition of a test and realized that we had opened the door there for a test services to people that were not serving or were not CPAs. So we realized we needed to do something with that. So we went about and we came up with a new definition someplace. The new definition of a test. And using this definition, we changed a couple of things and added a significant item. Now, if you'll note in line B of this definition, or in B, it says a test, and we took out financial statements because you all know, those of you that are in public practice, we as practitioners and as CPAs are asked to report or attest to many things that are not financial statements now. So we wanted to broaden that enough so that we captured anything that we may be asked to attest to. And so we changed the financial statements to services. And then we looked at the old definition to see what we had included. And in the old definition on line 3, the only item we had pulled in from the SSAEs was the examination of prospective financial information be performed in accordance with the statements on standards for attestation engagements. So at that point in time, any other engagements that were performed under the SSAEs were not attest engagements. So to correct that, we added line 5. And line 5 brings in anything that is performed under the SSAEs. So that's a major change that has taken place within the definition of a test. And now I'm going to let Noel come and pick up for a minute and share some with you.
Thanks, Ken. This is like the arcade game of whack-a-mole. You're going to have one of us standing up at any one time, so we'll jump up and down. I guess I should first tip my hat to the volunteers that worked very hard on this, and these are tough issues that were entwined in just how you define what you're protecting, who you're protecting, and how you're going to go about protecting. So there's some tough public protection issues entwined not only in the attest, but also, as we'll talk in a few minutes, about firm mobility as well. I'm just going to comment briefly on the other revisions related to attest that were fairly logical, flowing from the changes that we made in the definition of attest, enlarging, as it were, to encompass not only the old SAS 70 services that had moved to SSAE, but really broadening it in terms of new SSAE services as well. And some of those, I'm sure, are works in progress, to be sure. One note, the definition of report was broadened. That definition of report is a reading challenge. We've improved it. It's not perfect as a challenge, and states have tweaked it in their own ways, but at least we've adapted it to the new definition of a test and made it broader. As a public protection matter, you have the UAA prohibits, and most states' statutes prohibit, any non-licensee from offering or rendering any attest service. So you've got that public protection, and it's unauthorized practice to be offering or rendering that service unless you're a licensee. So we're not as dependent upon the definition of report, but it's still there, and it's a backup, and some states in their laws specifically rely upon the issuance of the report as being the trigger for board jurisdiction. So we made the change accordingly. Then the other changes I think are referenced there in the materials, added the new SSA services in that section, and made some other changes we can talk about later with regard to firm mobility, also in section 7 as well, with regard to the accountant's report, and then broadened in 14H the prohibition against non-licensee use of conventional language, which I think is going to be a challenge area in the future. And so it's important that we have that language right. I'll turn it back over to Ken for the next slide.
Noel's not quite as long-winded as I am. Now we're going to move on to the other change. There it is. Firm mobility. We struggled with this one. We had a lot of long meetings, a lot of conference calls, a lot of discussions, a lot of drafts. But in the end, we feel like that we came up with a good document that's going to meet the needs for those states that already have firm mobility within the states. We feel like it's going to relieve some of the pressure for those that are already practicing in multiple jurisdictions. And we feel like that it's really, in the end, going to give the states in which a firm is coming into more teeth from a regulatory standpoint. I don't know about how successful you are in your state, and I'm not here to try and criticize my state, but my experience with a cease and desist is that they don't carry a whole lot of weight, and it's hard to get them enforced. It's not something the DA's office is really looking for or wants to enforce because of the other issues that they have on their plates. So some states wanted to do this. 17 apparently went ahead without the model language, but that's okay. We were maybe too slow in getting it done. But other states were indicating they wanted to move forward. Now, let me make my next few comments, and please listen very carefully. As we went through this process, we passed at the UAA committee 2 documents. The first document that we passed was a document that changed the definition of a test. The second document that we passed was a document that adopted firm mobility and the new attest definition into the same document. So if you look at the 7th issue of the UAA that's just been released, a copy of which is in your materials, you will find that the mobility document is the one that is within the 7th edition. However, if your state wants to adopt the definition of a test and does not want to adopt mobility, and you do not, I say again, you do not have to adopt mobility, then we will provide to you a copy of the document that only has the attest change. I hope I've made that clear. So if you want to change your definition of a test, but your state does not want to adopt firm mobility, NASBA or the AICPA, we both have these documents, will provide to you the attest document only so that you can use the wording that we recommend for changing the definition of a test. And I think I have another slide that tells you that. So neither NASBA nor the AICPA, we have both committed to each other that we will not make a push for these documents for firm mobility to be passed in the states as we did with individual mobility. This is going to be a state-by-state decision. So if your state wishes to adopt mobility, then you need to look into the 7th edition, and that will take care of changing the attest definition as well as adopting mobility. If your state does not want to adopt mobility, and I know there's many of you that do not want to adopt it at this point in time, then you need to get the attest document and just look at changing your definition of a test. And I thank you, and we'll let legal counsel tell you some of the technical stuff that you're going to have to look at with mobility.
All right, thanks again, Ken. Let's see, there we go. I know as Ken aptly pointed out, there's some concerns in some states with regard to the firm mobility part of this and how it works and how you can protect your citizens. And I wanted to tell you in advance that for some pragmatic reasons as well as some legal reasons, I believe that in the long run, the firm mobility approach actually can do a better job of protecting the citizens in your state. There are other considerations, pragmatic and otherwise, that may hold you back. For some states, it's simply a matter in a constrained environment. The revenue might be a concern. But there are offsets even in this. I have to tip my hat at this point not only to the volunteers in general that worked very hard on this. My counterpart with AICPA, Virgil Webb, worked very hard with it as well. I think the task force leaders that Ken mentioned, Andy Duboff in particular, worked into the wee hours trying to get out something that could be acceptable to everyone. Talk first about the old approach. Here's a reality-based thing, is think about it. How many times in the past year have you successfully enjoined an out-of-state firm from practicing in your state? Or how many times have you successfully prosecuted a firm that was not licensed in your state from offering or rendering services in your state? How many times have you gotten a district attorney to get excited about pursuing such a matter? And what's the expense involved in that if you do fight that fight? And many do rely heavily upon the cease and desist orders that Ken alluded to. The problem with that is twofold, is that it still is a unilateral communication with someone in another state. Perhaps they stop, perhaps they don't. Then you have to turn to the injunctive or the criminal prosecution route. The other reality is out there is that recently agencies in the federal government, such as the Federal Trade Commission, have drawn their sights aimed at cease and desist orders, challenging the specific statutory authority to pursue them, and looking very hard at the cease and desist that are aimed at either out-of-state firms because of the negative impact on interstate commerce, or on unlicensed practitioners to the extent that it might be a restraint of trade. So we have to be careful in how we go forward with some of the old models. And the old approach was just that. You got someone by requiring them to register. If they didn't register, which was the essence of the problem, then you had those matters of pursuing it, and that was it. The firm failed to register, they were engaged in unauthorized practice under 14D, but the enforcement had to be the prosecution or civil injunctive relief. And then there was also in the current, the immediately preceding version of UAA, there was a concept that we introduced as part of enhanced mobility called the home office. That is, where is the client's home office, and they designate that. It was not consistently adopted among the states unless it gets to a critical majority. There are problems in mutual enforcement. It was not a completely well understood term as implemented, and it was, just had some workability issues with it too. So we had the old approach defined with those challenges and those limits. So what does the new approach do to deal with that? Well, the first thing is that by default, it automatically gives the board administrative jurisdiction, administrative authority over the out-of-state individuals and firms without requiring the risk of and expense of going into court for injunctions or for criminal prosecution. It means that your state board can protect your own citizens, initiating administrative process against that out-of-state firm. And as the law provides, you can impose discipline on that firm or the individuals involved with that firm as well. And that may include not only civil penalties, sanctions, but even revocation of the practice privileges as well. And those in the newer age, the multi-state and mobility age, the revocation of a practice privilege is frankly just about as serious as a revocation of a license itself, so that you can protect your own citizens without relying on another state. But of course, under the UAA, you also can expressly obligates other states to be reliable and to enforce against someone who has harmed citizens in your state as well. The key is, one of the keys is the trigger, that the authority of your board is triggered whenever a firm offers the attest service in the state. So if they directly intend to offer and direct their advertising in your state, they have to comply with your laws and rules. And that means not simply, you know, they don't have to comply with one thing, is the registration, unless they, of course, have an office in your state. But if they are misrepresenting things in their advertising, then they're subject to your jurisdiction as well. But they also have to comply with your requirements with regard to such things as peer review. The new approach gets rid of the, we felt somewhat confusing notion of the home office requirement before jurisdiction and registration obligation kicked in. And this revised approach actually rewards the firms that are compliant, that they do the firm ownership obligation requirements and the peer review requirements of your state as well. So it's a positive approach. As I apologize for, there we go. Just to highlight the firm mobility revisions, delete the home office. I think the other changes there are fairly self-explanatory. One important addition was that we added an obligation that non-licensee owners of firms coming into your state or practicing in your state must also meet the good moral character standard, which is already built in, and therefore licensees as well. Then the next couple of slides are, I think, a snapshot of the public protection advantages of this new firm mobility approach. And again, I concede there are some negatives, or at least one with regard to some revenue that I think can be offset. But on the other hand, there are some critical positives here that work out very beautifully with regard to just the way the law works and whether or not you have jurisdiction, whether or not you can do something to an out-of-state firm through your board administrative process rather than having to go through court. So I don't think I'll go through these in detail, but they're set out for you as some very clear ways in which this form of firm mobility can work. Again, it's in the context that Ken made very clear that NASBA is not going to go out and push it in a state that doesn't want it, but will help you if you decide to go in that direction. Ken?
Again, we can tell which one of us is long-winded. Enhancing public protection. Noel just, I think, covered this with his slides, but again, we feel like when mobility is adopted, that it's going to put your state board in a stronger position to protect the citizens of your state, and that's what our job is, protecting the public. So some of the tools that are out there to do this is 46 states are now on the accountancy and licensing database with NASBA. We have 43 states that are on CPA Verify. Now, these particular websites, as well as the CPA Mobility, are websites that will give you information regarding licensees and firms and where their licenses are and what sanctions may have been taken against those firms. But now the CPA Mobility is a website that has been designed and maintained by NASBA and the AICPA. And that's a website that you can go to and see what requirements you have to meet to go into another state to practice. Because I want you to listen real well again. Mobility does not relieve you of complying with the state's requirements in the state into which you are going. Do I need to say that again? Mobility does not relieve you of complying with the state laws within the state in which you are going into to practice. So if you happen to be in one of those few states that are left that does not have a peer review requirement, and you want to go into a state that does have a peer review requirement, then you're going to have a peer review to go in there because you're going to have to comply with that state's laws. So the CPA Mobility is a website that will help you find those. And if you're not sure what they are, you need to contact the state that you're going into to find out. But it doesn't do away, because you've complied with your state laws does not automatically mean you have complied with the state you're going into. The other thing I would encourage you is to, one, share with the UAA committee your concerns about any of the things we've talked about today. I'll be around, Noel will be around, Louise, who is a staff member assigned to the UAA committee, is here. John Johnson is here. We have Suzanne Jolliker and Matt Young with AICPA that represent the staff from the AICPA on the UAA committee. So we have people here that you can talk with, express your concerns to, let us know not only about the things we've shared this morning, but what I'm going to tell you now, the things that we have pending and that we'll be working on as we move forward. Right now, we're currently working on, where do we have? We're currently working on inactive CPAs. We removed the word retired. That was only found once in the model rules. Every place else in the UAA and the model rules, we use the word inactive. So we took out and removed the retired and changed it to inactive. So we're dealing with that. We have a task force that's working on what can inactive CPAs do. We have a task force and as well as staff working on the return of client records. How long do you have to keep giving client records back? We have a task force that's working on the whistleblower provision. As you know, the international market is working on this as well. I think it's the IAS something other, ethics. But anyhow, the international has a task force that's working on this. They put out 2 exposures. There's a roundtable meeting that's going to take place in July. And once we get some information back from the roundtable, we'll see what direction we're going to take with that task force and what we're going to do. Some of the things that we have on our radar are the disposition of deceased solo practitioners' records. If you're a sole practitioner and you pass away, what can your estate do with your records and your practice? A definition of independence that we would use to try and get it uniform within all states, and a complete update of our model rules. So that's where we're at. We're out of time, unfortunately, so I'm not going to ask for questions, but I would encourage you, if you have a question, talk with Noel or myself or the other people I've named, and we'd be glad to discuss these issues with you. Thank you.